10 seconds, 5 seconds, start. According to the respondents, their plea gave rise to a triable issue and they accordingly sought permission to file their written statements and contest the suit. The trial court, by its judgment and order, examined all the pleas, including the one based on Section 139 of the Contract Act, and found and held that none of the pleas raised by the defendants gave rise to any substantial defense against the claim of the plaintiff. Accordingly, it dismissed the petitions filed by the defendants, respondents by order dated, and proceeded to decree the suit of the appellant plaintiff for a sum of rupees 4 lakh along with cost and expense and future interest at the rate of 10% per annum on the decreal amount from the date of filing of the suit till the date of realization. In appeal, the Delhi High Court, as noted above, set aside the order and decree passed by the trial court and directed it to allow the defendants respondent to file their written statement and proceed to try the suit from that stage. The High Court noted that, relying upon Section 139 of the Contract Act, a contention was raised by the respondent that for recovery of its loan from defendant number 1, the principal borrower, the plaintiff, should have taken recourse first by either seeking to give effect to the promissory note or by enforcing the equitable mortgage. Neither of these remedies, which were open to the plaintiff, were taken recourse to, and the recovery was sought to be made straight away from the appellants. The High Court further held that the trial judge fell into error in holding that Section 139 of the Contract Act had no application to the facts of the case. According to the High Court, this was beyond the scope of deciding an application for leave. On those facts, the court held that the immunity which has been granted under the provisions of the Customs Act will also extend to such offences that may prima facie be made out on identical allegation, namely evasion of customs duty and violation of any notification under the said act. The court also found on a reading of the charge sheet and the FIR that there was no allegation against the appellant of any intentional deception or of fraudulent or dishonest intention. On those facts, the court held that once a civil case has been compromised and the alleged offence has been compounded, the continuance of the criminal proceedings thereafter would be an abuse of the judicial process. Reliance was also placed on the judgment of this court in the case of CBI and other. In paragraphs 30 and 31 of the judgment, this court held that dispute between company and the bank have been set at rest on the basis of compromise arrived at between them. The court noted that bank does not have any claim against the company. The court poses the question whether the power of quashing criminal proceedings was suffering from some disability. A person to represent the aforesaid category of persons is only competent to compound the offence, and in such cases the permission of the court is statutory required.